Hey, let's take a minute to talk about elective share law because a lot of people are unfamiliar with the elective share law here in the state of Florida. And so let's bring them up to speed a little bit on it, okay?
I agree.
Right. So elective share law here in the state of Florida says that by the very fact of being married, you have obligations to your spouse, okay? They are in two categories, okay? Category one has to do with the home that you live in, okay? And so if you are a married couple and you own a home jointly as husband and wife, one of you passes away, the survivor automatically owns it all. Do with it as you please. But let's say that the husband has a home in his name only and he passes away. The law says, the elective share law says that the wife at a minimum has a life estate interest in that, a right to use that house or live in that house for the rest of her life, and only upon her death would it go somewhere else like the husband's kids.
Regardless of a will or anything.
Yeah.
That's
So when we talk about elective share law, let's just say that the husband has a will that says when he dies, everything goes to his children from a previous marriage. The wife could step in and say, I don't care what his will says, I want what I'm entitled to under Florida elective share law. Two things. One is a right to live in his house for the rest of my life.
and 30%.
And then otherwise 30% of everything else. So if the husband passed away and he owned a home and $500,000 in cash, he's got a will that says when I die, everything goes to my children from a previous marriage. The wife could step in and say, okay, under Florida elective share law, I want what I'm entitled to, and that is a right to live in his house for the rest of my life and 30% of that $500,000.
Thank you, Tom, because again, I think it's when we do our workshops, as well as when we talk to people and we're doing our consultations, many people are not aware of that.
Most people are not. Yeah.
Correct.
And this really comes to play quite often because often people are getting married later in life.
Exactly.
They have
Second
children
marriages.
from previous marriages. They want us to write a will for them that says, Tom, when I die, and they've kept their wealth separate. Tom, when I die, write a will for me that says everything goes to my kids. And I say, look, I can do that for you, but you're going to have to sign a disclaimer that if you pass away, your spouse can step in and say, I don't care what his or her will says, I want what I'm entitled to under Florida elective share law.
Exactly. And that's why it is very important to seek the advice of an attorney, especially when you're talking about how you want your assets to go if you were to pass away, and if this is a second marriage.
Yeah. Well, most importantly, let's say this, that if you're getting married later in life and you've got children from previous marriage and you want to protect your wealth for them, hey, the way to do it is through a prenuptial agreement, okay? Get a prenuptial agreement. It is not a one-sided agreement. Whatever it does for the future husband, it does for the future wife. It's a balanced agreement. If you are already married and you didn't get a prenuptial agreement, you can do the same thing through a postnuptial agreement. In these nuptial agreements, you are simply waiving a right to receive a portion of each other's estate. Once you do this nuptial agreement, if you still want to leave your spouse something, you are welcome to, but you're no longer obligated to under Florida law.
And as we know, Tom, it's also better when couples are coming and asking these questions prior to getting married.
Right.
Only because of the fact that you're correct. Of course, you can do the postnuptial after. However, it's more involved.
It's more
There's more
involved.
to it. And it's much easier, simpler to be able to do the prenuptial and have everything set the way that you want.
Very
prior.
important lesson there, folks. A prenuptial agreement, much easier to do, much more likely to stand up if it gets challenged in court. Postnuptial agreement, much more complicated, more expensive to do, and more likely to be successfully challenged in a court at a later date. So
Exactly.
get the prenuptial agreement. Get it done before you get married.
Thanks, Tom.
All right.